Welcome to Case by Case. This is a podcast brought to you by Luke Zadkovich and Calum Cheyne of Xylophloid Zadkovich. Hello, Calum. Calum, how are you today?
I'm good. I'm outnumbered by Australians again.
There you go. There you go. Well, look, we've got an Aussie case to talk about here, so it'd be interesting to hear what you think of today's case.
It's a nice one because we kind of do the Zadkovich crossover of Australian law and English maritime arbitration.
Yeah, I enjoy delving into Australian law every now and then. And look, most importantly, we've got a guest. We've got a guest today, Leo Rees-Murphy, one of our associates in our London office who recently joined us. Well, it's already been a few months now, hasn't it, Leo? Time flies.
Hi, Luke. Hi, Calum. Yeah, absolutely. It's been, 3 months going on 4, so it's been great being in the team. Absolutely
Excellent.
fantastic.
Good stuff. And look, Leo joins us. He was at one of the top Asian Pacific law firms. Excellent. Well, look, I'll introduce the case and then let's get into it. So this is a decision of the Federal Court of Australia. It's the decision of Carmichael Rail Network and BBC Chartering Carriers, involving a vessel called the BBC Nile. The citation is 2022 FCAFC 171. And we have Justices Reyes, SC Darrington and Stewart giving judgment, which came down on the 12th of October 2022. And look, it's a really interesting case for anyone involved in shipping commodities around the world. I think this case is a great example of how local cargo liability regimes interact with governing law and choice of law and choice of jurisdiction clauses in bills of lading. So for any P&I club listeners out there, this is right down your alley. Any shippers, receivers, companies who are putting their goods on board ships or hoping that they arrive at the other end. Super important case, and I think it's a useful example to kind of see how local law in a jurisdiction around the world may then impact on, in this case, an English law and arbitration clause, and how the two interact with each other.
I know a couple of times, Luke, we've done cases where you've said that it takes you back to a case that you were working on previously, and this is very similar for me. There's a case I was working on a number of years ago. Actually with Joe, who's now one of the partners over at ZFZ. And we were battling against the law and jurisdiction provision that we didn't want to apply, contained in the contract. And one of the ways that we tried to disapply it was looking at whether the Australian courts had mandatory jurisdiction. So I was interested to see a discussion of exactly the legislation that we were looking at. And in that case, it also didn't work, slightly giving the game away as to what happens here. But for us, in our case, it didn't quite work out either, for different reasons. But it's some legislation in this one that I'm kind of familiar with for exactly the reason you say, which is that you can sometimes find that if you look at where things are happening, it's obviously a very international sector. So often you'll find that the issues are arising somewhere different to London. And if the choice of law is London or the choice of law is somewhere else, then you can always look into the local law and the place where the issues have arisen to see if there's something there that might help. Yeah,
I think that's right. And what I'm keen to get into as well is obviously we'll go through the facts of the case as we usually do, and I might hand over to Leo if you're up for it, to take us away on the facts. But I'm also interested in, as I always am, in the tactics and some of the undertakings that were given about what would be accepted as to the applicable law in the London arbitration. And I just wondered whether that was necessary. And in a way, it kind of deprived us of a decision on one of the key issues in the case, which we'll come on to in a moment. But as always, I'm fascinated by legal strategy on cases and how that plays out, and looking at the different examples of ways people have positioned to get the result they want on a case, but have they gone too far? Anyway, we'll get into it. Should we start at the top? Should we go through some of the facts?
Absolutely. And just building, I think, on what you were saying, Luke, and as well you were saying, Cal, this case is also quite prominent as one of the first examples where Section 11, subsection 2 of the Carriage of Goods by Sea Act has actually made it to judgment and made it to be litigated, so we can get an interesting judgment on some of the issues that are involved that we'll go through today. So a factual summary. On the 19th of December 2019, Carmichael Rail and One Steel entered into a contract for the manufacture and supply by One Steel of around 21,000 tonnes of hardened steel rails to Carmichael Rail. Carmichael Rail and One Steel entered into a goods and services agreement for the transport of the goods to the Whyalla facility in South Australia to a vessel of Carmichael Rail's nomination at the loading berth, the Port of Whyalla, and for the loading of the goods onto that vessel, including the supply of rail lifting gear for the purpose of loading and unloading the goods. Then in June of 2020, a booking note was executed by BBC and by Norwest Group Logistics on behalf of Carmichael Rail for the carriage of a cargo of steel from Whyalla to Mackay by sea.
It's probably worth mentioning there, Leo. Sorry to cut you off in your prime, but it's worth flagging that both of those places to non-Aussie natives like me are both in Australia. So it's an interstate cargo between two Aussie ports.
And importantly, they're both in Australia, but they're in different states within Australia. So Whyalla is in South Australia, and Mackay is right up the top on the Queensland coast.
And then on Christmas Eve, 24th of December, the BBC Nile arrived at the port of Mackay, where the mast issued notice of readiness. And then on Christmas Day, 25th of December of 2020, the members of the crew observed that a collapse had occurred in one of the holds on the ships on the starboard side. And as a result, the steel rails stowed in that hold were damaged to such an extent that they became non-compliant with the specifications for their use in railway construction. So the damaged steel was sold for scrap. And then on the 2nd of August, BBC gave notice to Carmichael Rail that had commenced arbitral proceedings in London under the Bill of Lading. And then Carmichael Rail brought the application for an anti-suit injunction in the federal court on 12th of August 2022, and that gives rise to the judgment.
Right, yes. So we've got two sets of proceedings here. We've got the local cargo claim against the carriers in Australia. That's one set of proceedings. Then we've got the London arbitration proceedings commenced by the carriers, and we've got this battle as to which of those sets of proceedings should be allowed to continue. And the cargo interests, Carmichael, have brought this anti-suit injunction in Australia. And for those that don't know what that's about, an anti-suit is all about arguing that a state court, so in this case the Australian court, should order that one of the parties be injuncted from continuing the overseas proceedings, in this case, the London arbitration proceedings. And this whole case is about whether that injunction should be granted or not.
You don't really see an anti-suit injunction for any reason other than one party saying you're prevented from taking action against us in that court for some kind of procedural reason, law and jurisdiction. It's not they aren't saying, for example, that claim is so bad that it shouldn't be brought in England. They're saying that claim procedurally cannot be brought in England.
Yeah, exactly. What's the best a forum and law to apply here, and that involves often a kind of an analysis of what is in the contract, what have the parties agreed to do, how that then, in this case, in the cargo damage sense, how that interacts with the various conventions that may or may not have been incorporated into the Bill of Lading through a clause paramount, and then the local legislation. How's it impacting with local legislation? So, Calum, should we start at perhaps the bill and looking at a couple of the key provisions of the Bill of Lading?
Yeah, that seems like a good place to start. So the bill's the two key clauses for the sake of this judgment are 3 and 4. maybe start with 4, which is law and jurisdiction provision. And this is the one that said that the law and jurisdiction for the bill is LMAA arbitration. So that's the London Maritime Arbitrators Association arbitration in London, and it would be subject to English law. So that's very, very typical what we deal with day in, day out in the London office over at ZFZ. LMAA arbitration in London subject to English law. And the other provision is clause 3 of the bill, which says, unless otherwise provided herein, the Hague Rules contained in the International Convention, you know what the Hague Rules are, shall apply to this contract. When no such enactment is in force in the country of shipment, the corresponding legislation of the country of destination shall apply, etc., etc. Basically, you have the standard application of the Hague/Hague-Visby rules into the bill, and those are a series of rules that apportion liability between a cargo interest and a vessel owner for cargo damage under a bill of lading, among other things.
Exactly. And in Australia, what we have in terms of its cargo liability regime is it has local legislation giving effect to the Hague Rules, the 1924 Hague Rules, that were also amended by the Visby Protocol, and that was in 1968. And then you have the SDR Protocol as well, 1979 SDR on how to quantify the package limitation. And so these collectively have been called in this judgment the amended Hague Rules. Somewhat confusing because I think most of us would just call them the Hague-Visby Rules, but it recognises that there may be some slight peculiarities there under Australian law. But importantly, that the Hamburg Rules, as is the case in many countries, were not enacted. And so you've got this kind of bunch of different sets of rules and amendments that the decision then goes on to refer to as the Australian rules. And under the Carriage of Goods by Sea Amendment Act in 1977, we have some amendments on the underlying COGSA 91. So it's COGSA 91, which is an Australian act, and Section 8 of that act gives the Australian rules, as we're going to refer to them, the force of law in Australia.
This is where it gets a bit kind of fiddly, because Section 8 of COGSA 91 gives the Australian rules the force of law in Australia, and then Section 10 says that the Australian rules apply to a contract of carriage by sea that is for the carriage of good by sea from a portion of Australia to another portion of Australia. That's under Section 10(1)(b). And the first question really, and it stopped being, this is what we're saying, kind of, it stopped being a question, was whether the Australian rules apply to this shipment. And both parties ultimately agreed that it did, and it seemed like, reading between the lines, it seemed like there'd been a bit of back and forth on that point when the application was made, ultimately ending in an undertaking being given by the party that had commenced in London, saying, yes, we're going to be moving forward in London, but we will agree that in London we will admit in the London proceedings that the Australian rules apply by virtue of this legislation. But that doesn't stop the London tribunal being the proper place, or the London tribunal having jurisdiction to hear this dispute.
Yeah, exactly. What did you make of that, Leo, of the concession and admission that the carriers gave?
I think it was interesting. It definitely took a lot of heat out of the first issue, being whether Article 3A of the amended Australian rules, which provides that any clause which relieves the carrier of liability for loss or damage to the goods arising from negligence, fault, or failure in the duties and obligations shall be null and void and no effect. So there was an argument that if the carrier was subject to a lower limit of liability under the English rules, then that shouldn't have applied. However, because they made that concession on the choice of law, it effectively nullified the issue and took a lot of the argument out of that issue. And so then Carmichael Rail fell back on trying to argue that, well, perhaps the tribunal would apply a different version of the Australian law, because ultimately the choice of law is a matter of for evidence to be proved in the tribunal proceeding. So definitely changed the nature of the argument that they ran.
Yeah, and that's what I kind of alluded to in the introduction for this case. I kind of feel like we've been deprived of the real battle here by the concession. And of course, many of you will know the Article 3.8 of the Australian rules that we're talking about, which is in COGSA and found in many other countries' laws, in that it's this reduction of liability provision. And if there's a clause, covenant agreement that goes to relieving the carrier or reducing their liability, then it won't be given any effect. It'll be null and void. And so you had this debate, and some of it is referred to in the judgment. They kind of, it's almost like the justices wanted to get into it. They set out some of the argument there about what would have been the case. Does English law have a different approach to Australian law? Would it have led to a situation where the carrier's liability was lessened? And then they kind of back off and say, well, we don't really need to ultimately decide the point because it's been conceded by the carrier that the Australian law, as applied, will apply. And it was interesting, again, just reading between the lines of this, I'm sure you guys picked this up as well, that there's clearly some back and forth in correspondence over language and semantics, and whether as applied meant something different to as interpreted, and whether carriers leaving themselves somewhere to go. My take on the outcome of that was, even if they were, the court made very sure in this judgment that the undertaking that was given was going to be very broad, very conclusive, very clear, that it's the Australian rules that are going to apply. So I don't think the carrier here can get too cute in the London arbitration over choice of law.
And I wondered if there was something. I mean, there's a degree of it which is maybe a softer. There's always your kind of hard law of you can do this and you can't do this, and then there's just the more kind of softer, persuasive side to law. And I wondered if the Australian court, in setting out in as much detail as they did the difference between the Australian side and the English side, were giving some material here to take to the London arbitration and say, look, this is a 3-judge bench decision on what the Australian rules mean when it comes to limiting liability, and the London court is going to struggle not to apply some of the findings that the judges have made in this judgment. I
think there was an element of that. I really do, and setting it out and making it clearer. So did you have anything else you wanted to mention on that aspect, Leo?
I think we've touched on all the major points, and then the real meat of the decision comes in at 11.2, which I think we're all keen to move on and discuss now. The crux of the dispute ended up being focused on a particular section of the Carriage of Goods by Sea Act. That's Section 11. Now, it's quite important, so I'll read out the relevant provision in full. The Section 11.1 provides that all parties to a sea carriage document relating to the carriage of goods from any place in Australia to any place outside Australia, or a non-negotiable document of a kind mentioned in subparagraph 10, subsection 1B, Roman numeral 3, relating to such carriage of goods, are taken to have intended to contract according to the laws in force at the place of shipment. And then subsection 11.2 provides an agreement, whether made in Australia or elsewhere, has no effect so far as it purports to, and then 2B, preclude or limit the jurisdiction of a court of the Commonwealth or of a state or territory in respect of a bill of lading or a document mentioned in subsection 1. And what some listeners with an incredibly keen ear may have picked up on is that in section 11.1a, you have a reference to a sea carriage document relating to the carriage of goods from any place in Australia to any place outside of Australia. But then in subsection 11.2b, you have in respect of a bill of lading or a document mentioned in subsection 1. So potentially there's this unintentional division between a sea carriage document, which was meant to be a term that encompasses bills of lading and all other similar sort of documents, and then on the other hand, a bill of lading as a separate document not covered by the category a sea carriage document. And that division, I think, opened up for argument for Carmichael Rail to then argue that, well, maybe a bill of lading means something broader than it would have meant prior to the amendments which introduced the sea carriage document category.
And even going back one step further, it's a surprising effect of this legislation if you just take in isolation Section 11 1A, which is that all parties to a sea carriage document relating to the carriage of goods from any place in Australia to any place outside of Australia are taken to have intended to contract according to the laws in force at the place of shipment. It's odd that doesn't expressly include shipments that are fully within Australia, this kind of interstate cargo that we're dealing with.
Yeah, I know that was part of the debate, wasn't it? Because it creates some interesting scenarios when you think it through. And Australia is a nation of federated states, so you've got this interplay between different states. So you've got interstate transportation within Australia. You've also got intrastate transportation, and then, as referred to here, you have export from Australia to another state, and it doesn't. It's only one directional, right? It's not import; it's only export. It's a really interesting provision when you think about it. But how often, Calum, are we here in a situation, whether it's a statute or a contract, looking at little lacunas or differences in language and then trying to work out, well, is that really what they meant? What kind of scenarios would be thrown up if you give this a literal interpretation? Do we look to for more of a purposive approach, and what's the intention here? We do it all the time. I think there must be so many cases we've touched on that are looking at canons of construction.
And it's interesting here because it's a little different when you're looking at legislation to when you're looking at the contract. Because obviously a contract is something which is voluntarily entered into between two parties. So you're trying to ascertain the meaning of those two parties. Whereas here, there's no counterparty. There's just the government creating legislation. So what did they mean? And I think in that situation, at least my reading of the judgment and my understanding of the law, is that the words have slightly more primacy than perhaps they would in a pure contractual dispute, where there's a little bit more room for the court or the tribunal to say, well, what did the parties really mean here?
Leo, would you like to touch on a little bit of the history here? I thought some of that was interesting. Is it worth going through any of that?
It's interesting just picking up again on what Calum sort of was alluding to as well. I mean, with the construction of the statute, every law student knows you look at the text, context, and purpose, and you have blue sky sort of drilled into you. But there's always a sort of lingering mind, I think, at the end of class in terms of students thinking, well, to what extent can we look to the history of the text and the purpose when overriding what seems to be the clear text of the statute? And I think that's exactly the issue that the judges were dealing with here when they were looking through all of the previous iterations of the Carriage of Goods by Sea Act and looking at the purpose of the text and whether really there was this intention to capture interstate trade within the provision. And their honours ultimately concluded that wasn't ever the intention of any of the previous iterations, and that was a really strong constructional reason not to give it that interpretation in the modern iteration, to exclude interstate trade from being captured as under this bill of lading, a separate provision.
It was interesting going through all of, obviously the argument had been raised that the intention here was to also capture in interstate trade. And the way that the judges looked at this was to say, was it ever specifically envisaged that this would capture interstate trade? They didn't. On my reading at least, the lens they looked at it through was, you have to show that they meant to include this. It's not enough to say you included all these other things, so surely this was something that you intended to include as well. Or there was some general wording when this was being discussed that said that you were trying to create a regime that did, broadly this kind of thing. They were looking quite specifically for some recognition in the history of these texts that they had specifically and deliberately sought to include the type of interstate trade that would have been captured here, and they just didn't find it in the best part of 120 years of legislative history.
Should we kind of get on? What was the outcome of this point?
So going back to, as Leo's been through this legislation, section 11 2, but going back to it, the question was, does this fall within it? And so the first question was, does section 11.2 of COGSA 91, should it be read as meaning that there is the sea carriage document relating to the carriage of goods from any place in Australia to any place outside Australia, should that also include any interstate trade? And that was basically a no. So the second question was then whether or not the agreement the agreement for LMAA jurisdiction and English law, whether that fell foul of section 11.2b, because as an agreement precluding or limiting the jurisdiction of a court of the Commonwealth or a state or territory in respect of a bill of lading or a document mentioned in subsection 1. And the argument there is then, okay, so if it's not a document mentioned in subsection 1, then it's still a bill of lading. And as Leo said, the keen-eared listeners will pick up on that. Is this an agreement in respect of a bill of lading or a document mentioned in subsection 1? The use of the or, I think they call it the exclusionary or in the judgment, suggests that they're two different things. So one, there's category 1 of agreements, and those are agreements that are in connection with a document mentioned in subsection 1. And this is not a document mentioned in subsection 1 because it's an interstate agreement. So the question then is, does it fall in bucket 2? And bucket 2 says a bill of lading. And the judge was saying, well, kind of at first blush, as you read through the judgment, the judge is saying, well, there is this, a bill of lading must mean something different. Given that it's a bill of lading or a document mentioned in subsection 1, a bill of lading must mean something different to a document mentioned in subsection 1. It must have some wider meaning. And then the judge kind of goes through, sort of takes you through the thought process, and the bill of lading, if they are two different things, and if bill of lading is broader than document mentioned in subsection 1, then the question is how broad? Is this any bill of lading which is ever entered into that somehow touches Australian jurisdiction? That would be absurdly broad. And the judge kind of talks their way out of this being two separate things, and ultimately comes down on ultimately finds that the law and jurisdiction agreement doesn't fall foul of this section 11.2b, this legislation.
For all the reasons that I think Calum has just talked us through as well, they particularly highlighted some of the absurd consequences that would arise if you have a case of it capturing any bill of lading at all. So the example they give is of a ship that gets arrested in Australian waters, taking a cargo from China to the Netherlands that has no other connection other than maybe just called it a port in Australia, then being captured by the legislation, how undesirable that would be. So get clearly some examples of some of the consequences of having such a wide interpretation given to it.
And what's your take on it, Leo? Just as stepping back and looking at this decision in the round. I mean, my view of it is it's actually quite a difficult one for the judge to come to a landing on. Not really helped at all by the legislation.
I completely agree. I think it would have been a case that both sides would have been reasonably confident on, likely going into the hearing. I think the text obviously supports a literal reading. The text is obviously very clearly in favour of there being two categories, and I think it was quite a task for their honours to then go back and explain by showing all the legislative history and the context of the statute just why that couldn't be the intended meaning.
Yeah, and I think also, not that it was relied upon here, but by analogy about what the effect would be if this legislation was given its literal effect. And the judges go on to have, I think it was 4 or 5 different examples of some of the absurdity that would run from a contrary decision, and also what it would kind of mean for Australia compared with some of its trading partners. And they also looked at this point around whether words should be read into the statute. And I always think that's an interesting discussion, whether it's a statute here. We've talked about the difference between construing a statute and a contract, but still we get this argument in contract construction as well, whether the court should start reading words into the provision to give it a different meaning. And ultimately they decided that should not happen here, and that it would be going too far away from the original language to start writing in words that the cargo interests here were seeking to argue. I think they were arguing that any other state or territory should be written into the provision. But it's just kind of going too far. So you can see like a court may be minded to insert a word here or there if it's a grammatical error or to make sense of a provision. But if it's actually changing the meaning considerably, then that's not really what the role of the court is, to start writing in words into a statute.
Yeah, I mean, we see it with construction of a contract, where the court will be very hesitant to write words into a contract if it's negotiated by two sophisticated parties who have had lawyers poring over it. And by extension, it's almost beyond that, right? When you have the government drafting legislation, you can't go and say, actually, you probably meant this, didn't you? You probably, looking at it, what you probably really meant to say was this. I'm going to add a few words in to give it that proper effect. It's almost, even beyond the most sophisticated parties drafting their contracts. You then have the government of a country passing legislation. You'd hope the words are in the right place.
Yeah, exactly. But it's with decisions like this that statutes do get revised, right? You have, the Law Reform Commission and these kind of national bodies that where their role is to look at the law, to make recommendations to Parliament on improving language, on improving effect. And this is one where you can see, actually, I wouldn't be surprised on the next revision of COGSA 91 in Australia if some of these language points get picked up, tidied up, tightened.
I'm sure they will, and it's not to say that the legislators have done a bad job on it at all. It's more the role of a court in adding wording into a document, whether it's legislation or a contract. There's a natural hesitancy to do it, and that hesitancy is even more heightened when you're talking about legislation, because then you get into all these questions of the role, the court overstepping its role, and starting to change the meaning of an agreement, starting to change the meaning of legislation, which is agreed by Parliament.
Yeah, I think the quote here is, the function of the court is to give effect to the will of Parliament as expressed in the law. Right? That's quoting Chief Justice Mason, Wilson, and Dawson from the Bolton decision in 1987. So look, I really enjoyed this one. Ultimately, it meant that Carmichael Rail's application for an anti-suit injunction against the carrier failed. There was some specific undertakings given by the carrier, as we mentioned, that they admit and will not resile from that admission in the London arbitration proceedings, that the Australian rules, the Australian law will apply to the cargo dispute. But as to the application to injunct the carrier to try and stop them from pursuing the London arbitration proceedings, that failed, and instead the Australian proceedings were stayed, put in a state of abeyance while the parties go off to London for arbitration proceedings.
All in all, it's a pretty good loss. They didn't get the anti-suit, but they did get a pretty helpful judgment from a detailed and helpful judgment on the Australian rules, on how they might differ to what the London tribunal think the rules normally are, and a very clear undertaking that the Australian rules will be applied in London. So, like I say, a good loss. Yeah,
exactly. And I'm not sure the win, of putting it the other way, the win necessarily gained a whole lot, other than jurisdiction, other than where they're going to have it debated, right? So yeah, I really like the point you made there, Calum, that there's some hidden subtlety to this decision that actually refuses the application with one hand, but on the other helps to say, here you go, take this over to the London Arbitration Tribunal, so that it's difficult for there to then be a debate around what does Australian law mean on some of these key provisions, like the free in and out, stowed and trimmed clause. What does that mean, and how is that looked at differently in the English situation? How is it looked at in the US situation? And how is it in Australian law? And this is what applies. And the parties agreed that this is what applies. Yeah, it's really clever. Really clever.
You wouldn't want to be the Australian law expert in the London arbitration arguing something different to what this judgment said.
Exactly. Any final thoughts for you, Leo?
No, I completely agree with everything that's been said. I think it was a very important decision as well, just to get some clarity on that lacuna that existed in Section 11, subsection 2. And so I think that will also be important for Australian practitioners or practitioners who are involved on a day-to-day basis with Australian law to now have the comfort that issue has been resolved.
Definitely. As we said at the outset, for P&I clubs out there and other insurers that are interested in cargo regimes, and on the sub-ro cargo insurance side, getting clarity helps. It helps the process. It means that claims don't have to go through this procedural wrangling again, and all the costs that are attendant to that. And instead, you can just get to the nub of the dispute and hopefully resolve them. If not, then have the dispute on what really matters, on the substance, rather than the procedural ins and outs. Anyway, guys, look, really enjoyed that. Thanks for being on, Leo. It's great to have you on as a guest. We're grateful for your time, and to all our listeners out there who have stuck with us, thank you. We hope that you've enjoyed this episode. We'll have another one coming your way next Thursday. Please do, if you haven't already, please do subscribe to us. It definitely helps us on the various platforms to get traction and all the rest of it, and means that you'll get the episodes dropped directly into your feed. So thanks again. Until next time, take care. Thanks, Calum.
Cheers, everybody.
Thanks, Leo.
Bye.